Good morning, everybody. Happy Super Friday. Welcome to TCF Live. I am Dan Soul. I am going to guide you through a 3-hour journey through Courtlandia that's going to look a little different today. As Jody pointed out in the chat before we started, hey, it's a holiday. What in the world are we going to watch? Well, I've got two hearings, basically, that I'm going to build this show around. There was a sentencing hearing yesterday in Judge Acalina's court that took about 90 minutes. Kind of an interesting case. The person there apparently sent like over 1,000 harassing texts to a bunch of people, from what I could find, that included the mayor of Lansing, Michigan. So we'll see what that's all about. And then Judge Mogan a couple of days ago had a suppression hearing, and that was also about 90 minutes. So we'll take a look at that. We don't often get to dig into these longer hearings here, so that'll be something different. And in between, if there's a magistrate court or something like that, we'll spend a few minutes there. At the moment, there really is no court to speak of going on. Judge Middleton has a landlord-tenant docket, which we're not going to watch, and there's one magistrate court running at the moment that I can find. So we're going to spend our day there. So buckle up, hop in, enjoy. This should be fun. We'll get started with, again, yesterday, Judge Acalina.
This is docket 24489FH. People of the state of Michigan versus Michael Shannon Doherty. Counsel, your appearance for the record.
Thank you, Your Honor. Randall Berman on behalf of the people.
Good afternoon, Your Honor. Toby White on behalf of Mr. Doherty. Mr. Doherty, join me up here at the podium, please.
Your Honor, I'm Michael S. Doherty. Thank you.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you. Put your hand down. Have you taken medication yesterday or today?
Yes.
And does that allow you to think more clearly?
Yes.
And you've been on it for quite a while now, is that correct?
Correct.
Is there medication you're supposed to be on that you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
And you've had enough time to speak with Mr. White?
Yes.
And have you reviewed the pre-sentence investigation report?
Yes.
You pled to count 6, aggravated stalking, punishable by 5 years, and count 7, aggravated stalking, punishable by 5 years. You recall that?
Yes.
On behalf of the people, any corrections, additions, deletions?
Yes, Your Honor. On the cover page, it should reflect that Mr. White is retained, not appointed.
That correction has been made. I'm checking the basic information sheet.
It's also on page 1 under evaluation of plan, second paragraph, first sentence.
All right, I'm changing it. I've changed it on the basic information sheet, and then under evaluation plan. Mr. What line did you say that was on?
Second paragraph, first sentence, it says appointed.
Oh, I see it. Okay. So retained. Is it anywhere else?
It's probably back on the basic information sheet.
I corrected that already.
I didn't see it anywhere else.
Okay, thank you. Any other corrections?
Yes, in the current convictions under where it says aggravated stalking, I think you can change that to count 6 and 7.
I did that already on the cover page.
Under plea agreement, I asked the court to add at the end on 5/126.
I'm sorry, under plea agreement on 5/126?
Correct. Plea, at the end of the long paragraph, I'd ask that the court add on 5/126, this court found defendant in violation of his bond/delay of sentence agreement, and the 2 aggravated stalking felony accounts remain or entered, or however you want to state it.
I'm just saying the 2 counts pled to shall remain or shall be imposed.
Or shall be what?
Shall be imposed.
As far as the body of the report, Your Honor, that's all the factual corrections and deletions that I had.
Thank you. Any objection, counsel, and any corrections?
No objections. I will say off the record, I reviewed this with Mr. Berman. We do have a change to the scoring also when the court's ready.
All right. And what is
I
that?
believe it's OB 12. Should be scored at 10 points. It does not change the ultimate guideline.
So total OB is 20? And is that on both counts?
Total OV 12, yes, correct, should be 10. The total is 20. It remains a level 2, and that applies to both sheets, Your Honor.
Those changes have been made. I'm going to make those on the basic information sheet as well.
Thank you, Your Honor.
All corrections have been made. On behalf of the people, does any victim wish to address the court?
There are 3, Your Honor, yes.
Thank you. Sir, please have a seat with your attorney at counsel table. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, nothing but the truth, and nothing but perjury?
I do.
Thank you. Put your hand down. Please state spell your name for the record.
It is James Noyes, Noyes.
Thank you. Sir, what would you like me to know? And thank you for being here.
Thank you, Your Honor. Your Honor, I never imagined I would find myself in a situation like this. I never expected to spend so much time in courtrooms or discussing circumstances as these with so many people. Only recently, I researched what a victim impact statement should contain. And this is my interpretation of my personal impact statement regarding this case. From what I have read, a victim impact statement should provide context from the beginning of the events to the present day, along with examples that illustrate the personal impact on the victim and in many cases, others affected. For me, it is also an opportunity to finally say things that have gone unsaid. There are not only 5 victims in this case, there are only 5 that chose to face them. I would like to begin by saying that everyone in my life is aware of the situation. I have spent countless hours discussing it with friends, family members, licensed therapists, human resource professionals, managers, and my parents, along with many other concerned and supportive people. The impact of this case has extended far beyond the courtroom and into nearly every aspect of my life. I believe that the events that led to this case began in 2019, if not earlier. At that time, I did not work for Mr. Doherty directly. I was a contractor. I remained with a reputable company and did not accept a full-time position until November 2021. However, it was during that period of time that the circumstances leading to the situation we're all here today began to develop. After joining what was then known as Rebel as a full-time employee, I immediately became skeptical of Mr. Doherty's character. The man before the court today has been treated for what has been described as a psychotic break, twice. Those periods represent 2 times during which he was determined to be incompetent. I only mention this to sincerely convey that my belief is that the person experiencing these psychotic breaks is fundamentally the same person he always was. The situation simply escalated into something none of us could have predicted. I witnessed and heard things in nearly daily company meetings that any company with a functioning human resource department would have found unacceptable. Yet I stayed because I believed in the company's vision. What I did not understand at the time was the extent to which people were being misled. One of the most difficult lessons I've learned from this experience is how selfish and manipulative a person can be while standing in front of 30 to 40 people who are pouring their hearts and souls into building something. The hard work and dedication of the employees was often used against them, often without their knowledge. After 6 months of employment, I was terminated by Mr. Doherty behind closed doors because I attended a public hearing on a scheduled day off and informed the company about the difficult truths that I had learned in court.
That
I learned in court. 2 months later, I was brought back by the receiver involved in a civil lawsuit, which has since concluded. Because I chose to stand up to Mr. Doherty and speak what I believed and still believe is the truth, I became what I have often described as Judas in his eyes. By that point, I have known him for 3 years. For 3 years, I have witnessed him at the height of his success, operating on borrowed money, abusing employees, and manipulating people and situations to his advantage. When those actions were exposed to others, I and many others became the targets of blame. As a result of this civil case, Mr. Doherty now has a multi-million-dollar judgment against him. Rather than appealing that judgment through normal legal channels, Mr. Doherty, while competent and not experiencing a psychotic break, embraced what he believed a vast conspiracy involving numerous prominent individuals. I remained at the center of his accusations, and as a result, a simple internet search places my name alongside people such as Cash Patel, and a federal lawsuit filled with allegations and falsehoods. In my view, those accusations were intended to damage my reputation. All of this occurred because I chose to stand up for what I believe was right, and I know was right. The challenge in explaining this experience is that there's so much history and context it requires over-explaining. And unfortunately, this has been my reality for the last 4 years. For 4 years, I've been repeatedly reminded how the decision I made to attend a summary of disposition hearing in 2022 would affect my life. Some may view these proceedings as the end of a journey. However, many involved in this case, others who know Mr. Doherty, and many people with whom I have discussed the situation with, believe it is not over. More importantly, many of us believe it will never truly be over. Mr. Doherty has created 3 LLCs that I am aware of: Never Surrender, Defy, and Rebel. To me, those names are significant. They reflect a mindset that he is entitled to define his own version of truth and continue fighting indefinitely for what he believes belongs to him. I say this based on years of observing him in those meetings and witnessing his leadership firsthand. In closing, although I know I could say much more, I respectfully ask the court to recognize that the man responsible for all of this requires continued oversight. While I sincerely hope my fears prove unfounded, I worry that within the years of probation, we may find ourselves back in this courtroom because of the same individual. And I hope that there's a way to protect those involved from any further continuation of these events. I fear Mr. Doherty's lack of concern for consequences of his own actions. I fear retaliation. I do not believe he is finished. I just think he's currently restrained by circumstances. Many people have told me over the years that I've been correct in predicting how much of this situation would unfold. And I do not want to be correct about my fears for the future. I ask the court to consider the situation through my eyes and through the experiences of those that have lived through it. There is a saying that a man with nothing left to lose is a man to be feared. And I genuinely hope that Mr. Doherty chooses to move forward, just like the rest of us have been trying to do. My concern is that, for years, he has demonstrated the inability to let go. And in my view, that mindset's reflected in the very principles he promoted: to defy, to rebel, and to never surrender. I would also like to reference a statement contained within the text messages that were filed in evidence in October of 2023. And I have the quote printed out. And no, I'm not gonna kill you, dumb fucks. If I was gonna do something like that, it would have happened last year. This is all in the court of law, and long term, I promise you, you will all get what you deserve. Those words were spoken by a man who was later described as experiencing a psychotic break, while referring to himself back to himself in 2022, when he did not see a solution to the problems he created, until then embarking on a self-created conspiracy theory that brought us all here today. Please, and I mean please, do not believe that the man who is before you today is anyone different. The man who's caused all of this remains intact, and he's only sedated and about to be free. I would like to ask for the extreme oversight of Mr. Doherty. And again, do not take his apologetic demeanor in this courtroom as genuine, because I assure you it is not. I would also like to ask that you rule for Mr. Doherty to wear a tether for the years that he is out on probation. A tether is the only way that the 5 of us will feel an ounce of security while Mr. Doherty is no longer in prison. I understand that if Mr. Doherty were to be sentenced to jail or prison with time served, once out, he'd have to deal with parole. It does not provide the same measure of oversight probation would. However, mandating that there's a tether is sincerely the only hope I have for peace of mind. Some would use probation to reflect, rebuild, and move on. But I fear it provides them with years of additional planning for retaliation. I fear the man who seemingly has nothing left to lose. I truly hope I'm wrong, but my gut intention tells me otherwise. Thank you for your time, your attention, and your dedication in this case, Your Honor.
Sir, are you asking for any restitution?
No.
And I really appreciate you being here. This has been a long, long case. Now, understand, you seem to know a lot about the law. You've been, as you said,
In and out.
And learned things you didn't want to know. But he has 681 days jail credit. So part of this is that he'll be out for 5 years. The statute requires 5 years of probation. If he does mess up, he doesn't have any jail time left, it would be prison.
Understood.
And I can only do 2/3 of the 5 years, and then it would be parole. So that's sort of the next steps, depending on how well or how poorly he does. So with you and hopefully the other victims keeping tabs and keeping us informed, maybe we can, hopefully we can keep him on the right side of the law and away from all of you. So I appreciate you being here. Keep us informed, and I've heard what you have to say. Appreciate.
Thank you, Your Honor.
Thank you. Next.
Thank you, Your Honor.
While we wait for the next person to come up, Great Granny, a $5 super chat. Missed you all. Thank you for prayers. We missed you too, Great Granny. Welcome back.
I'll take purchase.
I do.
Thank you. Put your hand down, please state signing correctly.
Todd, Todd, Haywood, Heywood.
Thank you. I know you two have been here for almost every hearing. What would you like me to know?
As Your Honor knows, I have been a journalist in this community for 40 years. I have been the subject of threats and attempted assassinations by neo-Nazis, by crazed MSU fans because I've reported about alleged sexual assaults by basketball players. I have been stalked by the army of God. I have had multiple people angry at me. The story that I did about Mr. Doherty should have been just a business story. Instead, it turned into what has been a nightmare. This man is sick. He is a danger to this community. He will go on to harm people. There is no question in my mind. I did my job. And for that, I have had death threats that have resulted in, just months after starting a job with 6 News, Nexstar having to spend $1,400 to put an armed guard in the lobby to protect not only myself, but the 80+ employees of WLNS TV who had to spend days worried about their safety because of this man's psychotic behavior. He is delusional and he's a danger. I want to be clear that I also had to inform my neighbors about his threats. They had to live in fear and concern because he could have taken out their anger on them if they'd intervened. His continued behavior and interruptions of my life, of the life of others who are involved in this case, has impacted my health. I was diagnosed with lung cancer and went through some very serious surgeries and therapy. And while I was recovering from a complication, that's when I learned about this obscene, fake federal lawsuit that he filed that accused me of horrendous things, including taking bribes to write a story. This man has impugned my integrity and my character and my abilities as a journalist that I have built over 40 years, a system that I need to have in order to do the work that I do. I need to have the trust of the people who talk to me. All they have to do is Google, and they're going to find this federal lawsuit that is filled with obscenities and lies. And I want to be very clear. He attacked my sexual orientation in that federal filing. He attacked my sexual orientation and my HIV status in the filings that are now sealed in this court. His behavior is repulsive. I need to make sure that he never goes off his medication again, because we've seen what happens when he goes off his medication. We get the courts weaponized against people. I heard in the last hearing that there was some talk about probate being instituted to have somebody there to say, oh, wait, he's gone off his medication. And there was talk about his family. His family has already proven that they are incapable of engaging that way. There needs to be an independent guardian appointed who is consistently monitoring his medication levels and making sure he's taking his medications. If he goes off his medications again, his psychosis and delusional paranoia and this giant conspiracy that he's created in his own mind in order to avoid accepting responsibility for scamming people for millions of dollars will result in somebody getting hurt or worse, killed. There needs to be an independent probate appointment. Also, the damage that he has done to my reputation, to the reputation of the others that are named in that federal lawsuit, he needs to file a sworn affidavit that that filing was a lie, that it was part of a delusional conspiracy that he dreamt up in his own mind. We need to have that as defense in multiple layers. Much damage. I can sue him for defamation and libel and slander if that's what we need to do. But you have that power to order that. He knows he lied. He knows that's a delusional conspiracy. It needs to be addressed. He is not well. And you saw that in this courtroom at the last hearing. After you had already ruled that the felonies would stand, he turned to us and pretended to be apologetic. It was fake. It was disgusting. It was horrible. It was appalling. And it showed this man is delusional. He thought we would somehow be like, oh, okay, forget it. I'm not going to forget it. You have damaged my reputation and made allegations about my sexual orientation, about my HIV status, and about my professional status that cannot be made to go away because of his behavior. I asked this court to go well beyond the 5-year probation. 10 years, I understand, is what the prosecutor is asking for. Great. If you could do lifetime, even better. I also want personal protection orders for every one of us that's named, and that needs to include his family who have enabled him throughout this. I appreciate the opportunity to address the court, and I'm sorry I have to do it.
I know you have been vigilant about this. I appreciate your time and everything you've said, and you asked for 10 years. He's only what he's pled to, and I was not part of this plea deal, but hopefully all of you contributed to a conversation with the people, but he pled to 5-year felonies, 2 of them. The maximum, and this is a legislative problem, because there are cases where I think we should be able to monitor longer, but the longest time I can monitor is 5 years. So I can't do anything for 10 years. But if there is any problems, he's out of jail time. He can't be sent to prison, but again, the law is for 2/3 of the 5 years, and he's already spent 681 days. But again, depending on what, if anything he does, new charges can emerge, and based on the history here, I suspect there wouldn't be as good of a plea deal, let's say. But it will take a community to watch him to make sure that he is taking his medication and following the orders of the court and the laws of this state.
I will be honest with you, Your Honor, we agreed to this because we wanted him to get the help that he needed, and it failed.
Yes, and there's very compassionate of all of you. I know there have been countless people in the community affected, and that is not lost on me. Are you asking for any restitution?
I believe Nexstar is going to be asking for restitution for I think it's $1,499.18 that they had to spend for an armed guard.
All right, and is there anything else you're asking for?
No, ma'am, just as long as he's kept away from us and kept relatively stable on his mental health. That's what we care about.
Appreciate that. Thank you for being here again.
Thank you.
There's one more victim, but before we get to that, Your Honor, I just wanted to remind the court that the defendant's been convicted of MCL 750.411I, which is the aggravated stalking statute, and subsection 4 tells us, and I know the court is dealing with probation all the time and not usually with the aggravated stalking statute, but it does state that the court may place an individual convicted of violating this section on probation for any term of years, but not less than 5.
Okay, so I can do more.
You can do.
It's rarely done. Actually, in 22 years of practice, I've never seen anybody ask for it nor it be done.
And so I had a conversation with probation and have an email exchange with them where they were telling me that it was a max of 5 as well. And so I sent the statute, then spoke to a supervisor who then went, I think, outside the county to ask someone. And the response I got back was, you are correct. It could technically be life probation, but we're going to recommend 5. And I said, that's fine. That's your prerogative. But there seems to be some confusion. But the plain language of the statute, 750.411I subsection 4, clearly states that it's any term, which borrows from our life sentence statutes, any term of years, but not less than 5. So I just want to clarify that.
And I appreciate that because I've actually never seen it done, nor have I looked at it that way. And probation always recommends the 5 years. So let me ask you this. Did you pass it by the appellate? Are there cases that have upheld more than 5 years?
Correct.
Do you know?
Before I email anyone anything, I've learned at this point in my life to not just start shooting off emails.
And that's why I'm asking,
I
because I know
couldn't
you do
find,
that.
yeah, I couldn't find any annotated cases or anything reference that. I asked a couple of people in my office who also said it's 5 years, and then I asked them to read the statute and then agreed with me that it's the minimum is 5.
Okay.
So on stalking, the misdemeanor, the maximum is 5. And I think it's mandatory. I have to go back and look at it.
It is mandatory.
But for aggravated stalking, it's mandatory 5 at a minimum. So I just wanted to
Okay.
clarify that.
I appreciate knowing that. So we've never done it. I don't know of any case in this county we've done it, but, or during my practice, I've not seen it. So, okay, good information. Thank
We
you.
got one more victim, and then I had one statement from a victim who couldn't get off of work and asked me to read it. But
Okay.
I can do that during my allocation as well.
Sir, thank you for being here. Please raise your right hand and do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury.
I do.
Thank you. Please state and spell your name for the record.
John Polderman, JOHN, POLDERMAN.
What would you like me to know?
So, Your Honor, I am a licensed attorney. I'm often in the courtroom. I don't know that I've ever given a victim impact statement before, so it's a little bit of uncharted territory. But I would like the court to know that my interaction with Mr. Doherty started as the court-appointed receiver by Judge Dragonchuck and administering the business known as Rebel, which was a cannabis grow operation. The initial meetings were, would characterize them as normal. We were able to interact, we were able to function, and we were able to operate the business for a period of several months. However, I think when it became clear that he was going to be unable to find a buyer for the business and that his house was going to be sold, things degenerated from there. It started with emails just to me, then my staff was copied, then there were emails with hundreds of people copied with various news outlets, and those emails became more harassing, as I know the court is aware. As far as myself personally, included photos of my family, of my children, stating that I was a psychopath and how could they have an individual like me as a parent, photos of my deceased uncle, mocking his appearance, my appearance, emails about my wife, making references to her ethnicity, numerous photos or numerous assertions that I was a white collar criminal, that I was going to be spending the rest of my life in jail, downloading photos from my Facebook account, which I have since set to private settings. Then there was the mailings to the office I was at the time, which had satellite offices as well. Those mailings had the similar assertions about criminal activity. They included photos of his dead children. As you can imagine, as those different offices received that and opened the mail, that was shocking to them. They wondered what was going on. I also volunteer at a legal aid organization that provides services to homeless and poor people. He found that website and put in a request for help, also defaming me and saying I should be terminated with the organization. I had to speak to someone about what was going on. Thankfully, they realized not to take it seriously. And by his own admission, he's mailed several hundred organizations copies of his complaint in which he asserts that I should be jailed, that I'm a criminal, among numerous other things. He's also appeared at the law firm I was at in disguise. He was wearing sunglasses and a hat along with someone else under the pretense of serving me. After that incident, we installed additional security cameras and security doors. I moved to a new office, which then added extra security as well in light of the allegations in the federal lawsuit, an extra security door. I had to show pictures of him to my children. I have 4 children, and asked if they ever saw him, to call the police if they ever saw him at our door. They should let us know and not open it. Also received a phone call on Christmas Day, or a text message that I cannot prove was from him. I researched the number and it seems to have been from a burner phone, but it said, "I hope you get what you deserve this year." And that's a common phrase that he liked to put in his emails. And once again, I can't prove that, but once again, harassment. I share the same fears and concerns as the other 2 victims. He's shown time and time again that after complying with the law or taking his medication, he decides he doesn't have to do it anymore, and he lashes out and engages in destructive behavior. And I wish him no harm. I have no ill will. I just want him to move on, get the help, and have no contact with me, my staff, our office. So I realize there's some back and forth as far as probation, how long that could go, but he has had numerous opportunities. This isn't his first encounter. During the civil case, I filed, I think, 6 different show cause motions. One of those he was jailed for, and then once he was out, the behavior started again. So he's had numerous run-ins with the law. He's had numerous court orders that have told him to do or not to do something, and really all he has to do is do nothing. If he does nothing, we would all be happy, but he finds that difficult, and he's often non-compliant. So I too would ask for the maximum amount of monitoring that this court can impose, and any sort of order as well, that he's to have no contact with his victims. That's, I think, critical. It's the most important, and would finally stop this climate of fear that he's been able to create. So I'm not asking for any restitution today, and I don't have anything further.
I appreciate you being here. I do know, I recently testified before a judge in federal court because of something that happened to my daughter and her friends. And I do know it was the same thing. What you said to me, I said to that judge. I'm not usually here in front talking about my own case, and it is very strange but necessary. I appreciate your words and your sentiments and your understanding in this case. And I'm going to do what I can do. You especially know the law, and I am here if there is even a thinking of a violation. What you've told me, you say you have no evidence, but you understand the difference between direct evidence and circumstantial evidence, and using your common sense. And I would agree with you that the same language, burner phone, and those pleadings, circumstantial evidence that did occur, they did occur from a defendant. So if you would just keep us informed so we can make sure this goes well and all of you are protected, I would appreciate that. And I so appreciate you being here. I know it takes a lot. Thank you.
Thank you, Aaron.
Finally.
Thank you, Your Honor. I have a statement to read from victim Mark, M-A-R-K, Andrek, A-N-D-R-E-K. He was unable to get time off of work to be here. He did ask that I read his statement into the record. Your Honor, my name is Mark Andrek. I'm providing the statement to explain the impact that Michael Shannon Doherty's actions have had on my life. I was previously employed by the defendant. Following the financial collapse of his company, he began assigning blame broadly, including to me, despite my having no responsibility for the matters he references. A few years ago, the defendant experienced what I can only describe as a severe mental episode, during which he sent a large volume of harassing and alarming messages to me, other employees, business associates, and even public officials. This conduct continued relentlessly over a period of 9 days until his arrest. During that time, I experienced significant stress and anxiety. The volume, tone, and unpredictability of the messages created an environment of constant unease. It was difficult to focus on my daily life, and I felt persistent concern about what might happen next. After his release on bond, I understood that certain conditions were put in place to prevent further contact and to ensure public safety. However, the defendant violated those conditions by appearing at the courthouse located within close proximity, approximately 3 blocks from my residence, despite not having any legitimate legal reason to be there. This incident was particularly unsettling, as it brought the situation physically close to my home and disrupted my sense of safety in my own neighborhood. Additionally, while awaiting further proceedings, the defendant filed a federal lawsuit containing false and damaging allegations about me, including claims of drug use and trafficking, as well as statements that I had been terminated from my position. These claims are entirely untrue and were made without any supporting evidence. Although the case has since been dismissed, the act of formally filing such allegations has caused me distress and concern about potential reputational harm. From my perspective, this filing felt like a continuation of the same pattern of harassment, carried out through a different channel after direct communication was no longer permitted. It reinforced my concern that the defendant remains focused on targeting individuals he blames, regardless of the facts. The cumulative effect of these actions has been a lasting sense of anxiety and disruption. I have had to remain vigilant about my surroundings and my personal and professional reputation in ways that were not part of my life before these events. I respectfully ask the court to take into consideration not only the defendant's past conduct, but also his willingness to disregard court-imposed conditions and to continue actions that have direct and harmful impact on others. Thank you for your consideration.
Thank you. No restitutions being sought.
That is correct, Your Honor.
What about this company who may request the $1,400 or so? Shall I hold that in advance? I don't see anything in here.
I think we should leave it open and get an exact statement and proof so that everyone's on the same page, Your Honor.
All right, and again, what was the name of that company?
North
Nexstar.
is the owner of WLNS.
NEXSTAR.
NEXSTAR.
Okay, thank you. On behalf of the people, what would you like me to know?
Thank you, Your Honor. First and foremost, I can't diminish or say anything better than what we've heard today. All very well spoken, very thought out victim impact statements. And I can say that I've been working with a group of people now for the better part of 2 years. With regard to this case, I've been to Mr. Polderman's office. I've driven down to the Oakland County area a couple of times to meet. It's been a tremendous amount of time spent, and that's my job, and that's fine. What I want to point to, Your Honor, just the tremendous amount of resources that we as a society have put into Mr. Doherty to get us here today. Notably, Ingham County, myself, Mr. Duane, my office, I think every public official that I could think of in this county were sued in that federal lawsuit. It was our county attorneys that filed the paperwork in the federal court and had to brief it out and submit everything and go argue, I presume argue the motions and have that case dismissed. And I know when I looked at the federal court filing, it appeared to me as after that occurred, Mr. Doherty went ahead and tried to appeal that decision. There were numerous people. I think the summons was issued for 300 plus people in that federal lawsuit. And as one of the victims, Mr. Noyes, related today, Kash Patel, members of the federal cabinet were sued who weren't even in office at the time that these alleged events happened. I know from dealing with this file that there was a point in time that Mr. Doherty drove himself to Washington, D.C. and tried to have a meeting with the FBI to discuss his criminal theories and paranoia of what was going on with all this. And I've said it before, and it's been thrown back in my face in some of the writings he sent to me. And I've said it, and I've said it all along. All he had to do was appeal what happened down the hallway with his business. That is the correct avenue when someone's aggrieved in court. What he has done and the wake of damage that he has caused for not only these 5 people, because they're the 5 who are brave enough to come here and face him. There are literally hundreds of others who wouldn't. And I want the court to be aware that that's what's gone on here. These are the 5 who said, I'm going to do something and try to help not just me, but everyone, and they're heroes. Your Honor, one of the things Mr. Haywood said is that at the last hearing, don't take what Mr. Doherty did when he turned around and apologized to be sincere. You don't have to take Mr. Haywood's word for that, because if I recall correctly, he turned around and apologized to me and to them, and then asked if we still saw in our hearts that we could forgive him and give him misdemeanors. Everything is done out of his own self-worth and what he wants. And while I recognize that it's going to be termed as a psychotic break and then another psychotic break, I agree now with the victims. And then I was foolish not to originally, that I don't know that we ever get to a point where Mr. Doherty is medication free and okay. I believe he is medicated and he is better. I don't think he is well. And I think we can see that based upon some of the writings and the statements. And I harken back to that May 1st hearing. Mr. White was cross-examining Mr. Polderman and asked for a moment and went back and consulted with his client. After they spoke, I only presume that Mr. Doherty was asking him about other points of cross-examination. Mr. White went back up and started cross-examining Mr. Polderman more about the house that was taken pursuant to the receivership. Just shows me that the defendant really is still focused on what happened, and I don't think he ever gets over it. He's been in the forensic center now for a long time. From what I read, he's getting injections to make sure he stays medicated so that we can at least get to this point. I fear what happens upon his release. And if you look at the PSIR, they have a psychological diagnosis for him that I've never seen before. And I guess I'm not a psychiatrist or psychologist. I probably shouldn't know them, but he has some significant issues. And I know that he has a supportive family. And that's good. But I also know that the family and families in general oftentimes mitigate and make excuses and tolerate things. I note that this court received a letter on May 26th from the defendants. It says Michael and Sharon Doherty, parents. And it states, "Dear Judge Aquilina, when Michael is released into the community, he will be living with us in Charlevoix. We run a tour business and could use his help until he finds suitable employment. However, wearing a tether intimidates our customers, and it is difficult to hide when climbing in and out of a van to load coolers and luggage. Seriously, that's what we're worried about. Is his parents' business and him wearing a tether at the expense of protecting those who have been harmed?" And so I second what Mr. Haywood said about a probate case in which his family is left to be the ones to supervise him. I hope that they take care of him. I hope he moves up north. I hope he lives a happy, productive life. I hope he is a good father and can co-parent for his son. That was part of why I entered into the original plea agreement, to reduce these to misdemeanors and just try to get him the help and get him back into society. It failed. And I don't know that anything this court does is going to be successful, but we have to try. We have no other choice. And so that's why I feel like the plea that I entered into gave him the rope to either hang himself or be successful. And here we are. I am asking the court to impose 10 years of probation. I think it's legal based upon the plain language of the statute. I think I could ask, and rightfully should, to have it be more, but I think that that's a significant amount of time. I do think a tether is needed, and not just because I'm saying it. You've heard it from the victims. They need some kind of sense of safety and measure from him. I think there needs to be exclusion zones. I think Mr. Haywood made an excellent point about that federal lawsuit. There is one of the victims that I know of who is going to school and has to go get a license to do his job that he's in school for. He's going to have to go through a background check, and it's already brought up to him that an initial search of him is bringing up this federal lawsuit. We've all been accused of doing dastardly things and being unethical. And as far as these victims go, John Polderman being involved in a criminal enterprise and just all kinds of things. You heard it about his horrible tragedy that occurred to his children, and everything that's gone on here. It's all sitting out there in that federal lawsuit. I'm involved in that. This court's involved in that. This county's involved in that. In fact, judges in Livingston County are involved in that. I mean, that was over 300 people. So if there is something the court has that can order him, instead of writing apology letters, no one wants those. I think something be great to be filed in the federal system saying that I had a mental break and none of the things contained in that lawsuit are true, because they're horrible. And thankfully, on behalf of the county, myself and Mr. Duane, our lawyers went ahead and got that all dismissed. Can you imagine having to sit? I sat and looked. It was 400 pages of just rambling and pictures with things written down. How do you respond to a lawsuit like that? And the next thing I know is I don't, and there's a judgment, and he's got a U-Haul truck at my house starting to load up my furniture to satisfy his judgment. And that stuff is dangerous. And in fact, when it was going on, I had to call the state bar and said, look, this guy has sued me. He's accused me of doing all kinds of things. Do I have to not prosecute him? And they said, no, it's the exact opposite. We cannot allow defendants to choose who prosecutes them, because we would never get to court. They would constantly sue or grieve, and that's just part of the stuff that we have to endure. So on behalf of the victims, I'm asking the court to enter some kind of order like that. I can't say enough about what these people have been through, and I acknowledge that the 5 of these men are very brave, and I thank them for coming forward, because I can tell you more that I received phone calls from Lansing police about other people involved that wanted to know if no contact could be extended, who weren't brave enough to come forward. And the answer was no. We can only protect the people who are technically victims. But at least we got to a point where we could get Mr. Doherty the help he needs. And I pray the only thing that comes of this is that he continues to get that help and lives a happy, productive life with his family, with his child, and that he is a productive member of society, which should be the goal of every one of these cases. I agree prison's not the answer here, but I do think an extended term of probation with tether is warranted here. I ask the court to sentence accordingly. Thank you.
Thank you. Counsel, please approach to your client.
quick pause here before we move forward with the hearing. Good morning once again, everybody. TCF Live on a Super Friday, doing it a little bit differently than we normally do. Most all of the courts are not in session today due to the holiday. This, again, is a sentencing hearing in Judge Acalina's court from yesterday, so we'll continue with that. Judging from the stats, there's probably a bunch of new people out there this morning. If you're new to the channel, do take a moment and say hi to us in the chat. You'll find that you love this group. A lot of really good people out there. Anyways, let's continue.
Mr. White, what would you like to know?
Thank you, Your Honor. I'd like you to know that Mr. Doherty is going to address this, but in no way does he discount the problems that he's created for these people. And I might add me, I was named in that lawsuit. So I'm pretty well aware of all this that was going on. I'm going to go in reverse order and address the tether first. And I have to say this, and I've been in front of you how many times for how many years? I've never said this before, but these same people that write these letters and talking about how they need safety and they need a tether are the same people you glared at, because when Mr. Doherty was here a month and a half ago, they were in the back of the courtroom snickering at him. They're not afraid of him. Now, Mr. Doherty was on probation for 8 years. I'm sorry, for 8 months. And didn't have a problem, and they came down here on April 1st, as we all know. And there were issues during that period of time, so he can be successful on probation. He was on medications that proved to be improper medications for him. He's on different medications now. And there was, and for obvious reasons, I could not call her as a witness before, but there was actually a family doctor that was saying you can cut back on your medications, and that's when he went into the re-break. Okay, that's malpractice. Now, since then, he's been back in, as you know, for a long time, and he's been working in the forensic center. And during that period of time, 2 things. 1, changing his medication, which he will acknowledge he will need to take indefinitely. 2, they also acknowledge that in his second time down at the forensic center, the first time he was resistant. He didn't want to take any medication. I don't need any medication. The second time through, he had a change. He's not cured, but he had a change. He cooperated. They worked with him on different medications and counseling. And so he's a different man that stands before you. These professionals at the Center for Forensic Pathology, these professionals, they're not saying stuff like, Michael's just running a scam on you all. He's going to spend his probation period getting ready to come back and really come after these people he doesn't like. That's not their conclusion, and they're the professionals that we turn him over to get this kind of an analysis from. In terms of violence, he made it clear, even in his worst state, in these awful, and he acknowledges they're awful and upsetting papers that he filed and notices that he sent and emails and so forth. But even that long ago, when he was in the depths of it, he said, if there was going to be violence, I would have done it long ago. His nature is not to be violent. His nature is his mouth, which gets him in a lot of trouble and got him in a lot of trouble this time. And I would point out just briefly, when he came down here on April 1st, which is when he got arrested for being in the courthouse and in the county without permission, all right, he came right to the courthouse. He notified your office. He notified the probation office. That's what he was doing. Okay? Wrong. Okay. But it wasn't like he snuck down here because he was going to sneak up on people and do harm. He was in his misguided state thinking, this is how I file my lawsuit. And it's not an apology for the pain and suffering he's caused people, but it has to be taken in the context of, is this an evil man? No, this is a man that needs psychological help and medical help in order to maintain himself. Up in Charlevoix, he has contacted the CMH up there. They cannot do something, some places can take a phone interview. He cannot, and I've verified this with CFP. But they said, as soon as you're released, get up here. We'll get you an appointment. We'll get you a A psychologist will get you a psychiatrist and, get you on and continue on the medications, which he just freshly took yesterday. So he's at the very beginning of the cycle of the medications that he has to take periodically. So that he will be there at CMH, if not tomorrow. I don't know if they're doing Juneteenth Monday. So that's what I would like to point out. And I think that I want to just emphasize again, it's not the tether that protects these people. He was off the tether. There was no issue. And we've been through this so many times in certain businesses, having a tether on your ankle, it ain't good for business. People see it one way or another, and it's not very good, and it doesn't really stop him from coming back down here. Sure, he'll get caught, maybe sooner, maybe not sooner. He cuts it off, and, it looks like it's still up in Charlevoix, and he drives on down. That's not going to give them the security that they need. And like I said, I doubt they really need that physical security they're talking about. If he gets on a computer and harasses them or does any of these other things, you can immediately pull him in. He does have some prison time available to him if he doesn't follow through. But all the indications are from everybody professionally that has worked with him is that he can do this and that he's going to be willing and able to stay on his medication. In fact, having that conversation, I contacted a very reputable firm, and so did his family, in Charlevoix about the guardianship idea. They nixed it. They said that's not appropriate. Probation actually is appropriate and will do more for him than having a guardian appointed. So wanted you to know we look at that. We're looking at all the avenues for taking care of Michael. The most important one is Michael staying with his program, staying on his medications. And again, it's not my place to apologize, but he is going to apologize, and it is a sincere apology. I totally reject the idea that when he apologized, it was in any way phony, and for the reasons I've stated, because I don't trust people that laugh at you in court one day and then come in and write a letter saying you're scared of them. Thank you.
Well, for the record, I've never glared at the victims. I believe I was probably glaring at defendant because he did turn around and try to play let's make a deal with the victims. That was a problem for me. That was not an apology. That was let's make a deal with the victims. They were not going to do that. He's re-offended and they feel unsafe. And that was a horrible situation that, again, he caused. So, sir, what would you like me to know?
I just have to say they were chuckling and amused.
But
I think they were chuckling and amused at the thought, when I don't want to speak for them, they certainly can speak up and the prosecutor can, but I think they were chuckling and amused that somehow he would play let's make a deal after all the damage that he caused.
there's no amusement involved in this, Your Honor, and I think those statements are inappropriate, and I'll leave it at that.
Thank you. Sir, what would you like me to know?
Well, how are you today, Your Honor?
Well, this is a sad case, sir.
Yeah, I know. I know it is. Because I ultimately let a lot of people down. I had Toby, Berman, even some of the other victims. I'm sure everybody was working together with me on a plea, and that plea ultimately didn't work. It was a half-second decision to file it in a courtroom in a federal lawsuit. And if I could take that back every day, every hour, I would. The problem was I was trying to avoid probation. Probation to me is very scary. This is not my element at all. In fact, I wasn't even sure I was going to have the nerve to speak in front of you, Your Honor. This is very intimidating. And you do have my life in your hands right now. And
well, let me just interject here, sir.
Sure.
If it's not probation, it's prison. You have prison time. Would you like to go to prison instead of probation?
no, ma'am.
Okay.
So, I know I screwed up, and after reading through the amount of statements and stuff, some of that maybe maybe a little over the top, but ultimately there's something going on there. I caused pain and hurt in others, and I'm sorry for my part in that. They say hurt people, and I was very hurt with this whole thing going on. Having your company ripped away from you is like no other. So that's where with Mr. Polderman there, Mr. Polderman, I apologize. I apologize for taking some screenshots of kids, family members. It's not okay. I was hurt. I was not thinking clearly. I thought this was kind of a game to try to bring me back to some sort of a man again. You know, that was a problem. I didn't feel like a man. And I was acting out and doing some stupid things. Todd Haywood, you and I did a little bit of work together back in the day with the newspaper, all that stuff. So the last thing I wanted is to offend people. I am really trying to move past this way more than you guys realize. James, for you to say there, you know, that maybe 5 years from now, I'm going to plan a whole nother attack or something, that's just crazy to me. There's no way. I mean, look at me. They've taken everything from me. Even my wife. They've taken everything. And so do I need pity from you? No. But just some understanding with a fellow man. We go to battle sometimes. You guys watched me in that building. Like we went through battle after battle, and I had to fire people along the way. It didn't mean I didn't care for them. I ended up bringing back people too like that. So,
So turn around and talk to me. I don't think they want to talk to you. No, you can't. You can talk to me, you can say that to me. I don't think they want you to talk to them and to make excuses. You're making excuses. You're the one that caused the pain and hurt. You're the one that caused yourself to lose things. And men don't hide behind computers and use pictures and other things to speak for themselves. They ask for help. They don't do what you did. So let's get off of that train and talk about something meaningful.
Okay, bottom line, I want to tell them that I'm done. I'm done. That was the point of that. Sorry if it wasn't perfect, but it's done. I have nothing left to say, to do. That final lawsuit was, you can't do anything else. So that I'm literally done. And for the last year plus, I have been focusing on that very thing, just living a simple life. And, you know, we have barely any left right now, but I'm going to have a simple life and I'm going to enjoy it. But that was what was driving me, because I think even Berman, you know, what is driving this guy? When you get up there in the millions and all of a sudden that gets taken away from you, when I was planning on retiring in like 3 years, that takes away the foundations of a man like no other. But I apologize to the court, the prosecutor, Randy Berman, all of the victims, including the ones that are not here, and to my family and for my actions over the past few years. They are not a reflection of who I am or the values I hold. Although I understand how my conduct appeared alarming, I have no prior criminal history, and my behavior has always been nonviolent. I am absolutely not a danger to society or to any person involved in this matter. After suffering several losses during a short amount of time, I was traumatized and devastated and made some poor decisions. but I know now that I will be able to leave the past behind and move forward in a positive manner. I will continue receiving therapy and support, and I have no desire to have further contact with the victims. Literally, as of today, that's why that was my last piece to them, Your Honor, just kind of trying to get us all to be able to heal and move on from this. After reading their letters, I realized some of my writings cause these people concern, and I am truly sorry, as that's not how I operate. Again, I am not a violent man, and it's important to note that I have not had any physical contact with the victims in 4 years. When I leave here, I would like to help my parents with their business, as they are approaching 80 years of age. Wearing a tether would severely limit my ability to help them by intimidating their customers and interfering with the mechanical needs of the job. It would also hinder my ability to move forward in general. I will be living 3.5 hours away from anyone involved, and I have always been open about my whereabouts and very mindful of the no-enter zones in the past. The main question here, Your Honor, is if I'm done pursuing this. And the answer is unequivocally yes. I don't have an ounce in my body to keep fighting such a lost and miserable cause. This has been pure torture for me. I apologize to the victims times 1,000, but I'm telling you, I've gotten mine too along the way, and I'm really looking for this to be done. That's why, to me, after wearing a tether for 60 days, it is unreal. And I can't wrap my head around how I'm going to do that while having to go apply for jobs as a felon now. I don't have a car yet. All kinds of other things. I'm going to have to, probation, medicine. I'm being given so much, and I am fresh out of jail here, basically. I need a chance to survive, a fair chance to survive. And I'm begging you to give me that shot and let me prove myself off the test. I promise you, we will never have to have that conversation again. All of those guys over there are going to be safe and then some. I'm going to be 3.5 hours away and finally able to rebuild again. That tether, the mental trauma I had from it in just 60 days, it's like still being in jail, Your Honor, and I would really like to be released. So thank you so much for your time. You let me know if you have any other questions or comments for me.
Sir, your actions, you say that you didn't intend to physically harm anybody, but you did, sir. Each one of your victims has trauma. You talk about trauma from wearing a tether. They are tethered to your bad acts. They don't have the one thing that cannot be taken away from any human being is their name. We all have our name. They had their good names, and you soiled their good names publicly many, many, many times over to their coworkers, community, and to their family. How do you undo that? I don't think that you clearly understand how deep your actions cut the victims. One of the things that I'm going to order is that you go on the computer and you scrub it clean of every single thing you did to any of your victims. They should not have to live with the vile things that you posted or said. I don't know if you've done that. I don't know if anything can be really taken off the web. What is your responsibility? You put it there, take it down, sir. You say that your threats were verbal. You didn't intend to take any further action. How do they know that? What everybody has learned from you is to expect the unexpected. Your statements caused fear. One of the things is, does the person making a threat have the ability to make the good on the threat? You certainly had the ability to make good on the threat. You came at them from nowhere. At one point, they trusted you, liked you, worked with you, and you turned on them, not once, but in many vile ways. So their fear is very real, and I appreciate that they don't believe anything that you say. And I deal in evidence, so it's going to take evidence to prove that you're going to stay on your meds, that you're going to stay free of everybody, that you're going to be law-abiding and do the things you say. You have a history here of saying it, doing it for a while, going off your meds, and then the worst happens again and again and again. I do have hope that now I have lovely letters, a dozen lovely letters from lots of people, your family, Virgin Arrow, lots of people, community leaders, saying, give them another chance. We're here to support them. The question I have for them is, where were they in support of you when you were sick, getting you help, stopping you, intervening? Nobody did that. So hopefully now they will recognize when you are in trouble and get you the help before you lash out at anyone again. So if I thought you were not worthy of being rehabilitated, I didn't have to accept this agreement. I didn't have to put you on probation. I can send you to prison. But I do believe in giving people a chance to put themselves in prison. You have the keys. If you do not do well, I will send you to prison because you're out of jail time. And I imagine whether it's Charlevoix County or some other county or this county, other charges will be filed because that's what you do. You go from 0 to 1 million really, really quickly and cause harm. So you need to understand that we will all be watching, and I hope that that motivates you to stay on your medication and to ask for help. You're really focused on the wrong things. What you're focused on is me. It's going to cause me trauma to be untethered. I need to do this. I need to do that. Well, these victims have a lot of healing to do. And first and foremost, they need to feel safe. They need to have their reputations untarnished. The only one that can do that is you. So you will also write a letter in regard to the federal lawsuit that says that you were having a mental breakdown, and that none of the allegations are true. These victims are not saying we are going to sue you for defamation or any of the things they could do. All they're saying is give us our life back, do a letter. We don't want to engage in any more courtrooms or lawsuits. And I think you owe them that. I would also hope that you would ask the federal court to see if they would seal those records, as I have sealed records here. You can't buy a reputation, you have to earn it. And the people that you hurt had earned theirs until you took it down peg by peg by peg. Because sadly, in this day and age of computers, even falsities that are put out there are believed by some and are never forgotten. So it's going to be part of your probation to clean up the mess that you made everywhere. And sir, I've never asked you to, or any person who's talked in front of me, to say things perfect. But I do want them to be meaningful. The only way that you can put some meaning behind your words is by the actions, because I deal in evidence. And the victims deserve to see that evidence as well. Now, I don't know in regard to probate court, I think somebody said, or maybe you said your parents are 80 at some point. I mean, we all have an expiration date. And if things go in order, they will pass before you. I don't know if you have siblings or other people who will help you, but it may very well be that the probate court needs to intervene to kind of help you. But I agree that if in fact that does happen, that it should not be a family member, but rather someone trained who you hopefully get along with, who the court appoints and can keep you apprised of whether or not you're taking your meds. And perhaps as you get older, I don't know what your diagnosis is long-term or any of that. It can help you in terms of finances and other things, because the problem is, and I see this all the time, and I don't have a crystal ball, but in the crystal ball of experience, people like you sometimes are then taken advantage of. So I don't know your diagnosis, but you ought to work with your family and have a long-term plan. And I'm going to actually order that you work with your family and therapist to have a long-term plan in the event you don't have family members who are willing or alive to support you. Because otherwise, at some point, you will be in prison. So have a plan to make sure that you stay.
Sisters too.
You know, again, I don't know their situation, I don't know if you listen to them, but you need to have a plan in place so that you know that there's somebody else watching. Because it seems to me you do better when people are watching you, but so you need to ask for help. A man isn't somebody with millions. A man doesn't have to be successful in business. A man needs to be kind, respectful, accountable, and have the ability to ask for help when needed, because those are signs of a strong, capable man. I think you want to get there, but so far all you have shown is weakness and depravity at the expense of others.
All that shows what?
You have shown is weakness and depravity against others.
I have learned a lot.
And you'll continue to learn,
Yeah.
sir. But if you don't, as I said, there may be other charges and prison, and you won't do well in prison. So think about that. You are going to be on probation for 120 months. That can be extended if things are not going well. You will also have, I don't know for how long, but at least until we can make sure things are going very, very, very well, you will have a tether with a GPS so that we make sure that you are not within 1,000 feet of any of your victims. You will not have verbal, written, electronic, or physical contact with Todd Haywood, Mark Andrick, Alex Centeno, James Noyce, and John Holderman, including Judge Joyce Dragonchuk, Mayor Shore, and his city attorney, who I believe is Joe Root. And they are named in here as part of the attacks that you had prior, and you will also not have any contact with any of the named people in your federal lawsuit. I'm adding them all as victims. You are lucky they're not in this courtroom and didn't join in this. We have 5 brave souls who want to see you get help. Now, I don't know how you feel about them, But in my book, they could have asked for a whole lot more, and they didn't. And each one of them has said, we want to see him get help. So honor their gift to you. It's not my gift to you, it's their gift to you. And you did horrible things to them. And I know you don't like the tether, and I don't care. They don't like living with the trauma of what you did. If you can't work because people see the tether, I have people working all the time with tether. Wear longer pants, thicker socks to go over it, not under it. Do whatever it is you can to cover it up, but it's going to be there, plugged in every day. And then we'll see where you are and what you're doing. I'm not saying it has to be forever, but I think that your victims deserve to know where you're at and to be able to call law enforcement if you get in their way. No contact with them means not just a distance. You will not be within 1,000 feet of the residence, school, or place of employment or their immediate families, but you will also not contact them directly or through third parties. You will not send them Hallmark cards, apology letters. You will not contact them through smoke signal, carrier pigeon. Don't get creative, because I'm not creative in this regard. My creativity lands you in prison.
Is it easier to say just Ingham County? You guys staying out of Ingham County, or how does that work?
I don't know where these people go. I mean, I go to Charlotte, you might see me up there. There's not a no contact order with me. I don't know where they go, but
So
where do you see?
what happens at that point? I run into random.
So let's suppose you see Mr. Polderman, and he's walking down the center of Charlotte Way because there's a Venetian festival and you're there. You turn around, you go the other way. You don't say hello, you don't wiggle an ear, you just leave. You end up at the same ShopRite or whatever. I don't remember the name of the grocery store there. And you see one of the victims, you leave your cart and you go home. Or you go over to Petoskey and go to Myers over there. You just do an about face and you leave, you say nothing. There are accidents that happen in this world. So I'm not saying don't run into anybody, but if you do, you just do an about face and you leave. I don't consider those as violations. Those are accidents that happen sometimes in terms of communication. You can talk to your lawyer when I'm done, or if you need, do you need a break?
Did you talk right now?
Just questioning, 120 months, is that 10 years?
Yes, sir.
Man,
I know.
I thought it was 5.
Well, apparently the statute allows, and what I've heard from these victims is they need a breather from you, sir. So, you know, the other part of this is that there's also part of the statute, I'm going to be honest with everybody, that says that after half of probation is served, you can ask if nothing has happened for it to be decreased. I don't know whether I would grant that or not, but this way it's not going to be 2.5 years. This actually does impose, at a minimum, the 5 years. It can go up to 10. It can also go up to 20. If he does poorly, we can increase it or just send him to prison. I don't know. My crystal ball was not issued with my gavel and my robe. You shall not violate any criminal law of any unit of government. Oh, by the way, no contact through third parties. So don't reach them through telling somebody to write them a letter, or call them, or what have you. And as I said earlier to Mr. Polderman, circumstantial evidence is a thing. So no burner phones. If it's your language, we think it's you and we can trace it. If we call law enforcement, if we have to do all that, it's not going to go well. So don't get creative, sir. You'll not leave the state without the consent of this court. You shall not use, possess, consume, purchase, or be in the presence of alcohol, illegal drugs, or drug paraphernalia, including marijuana, unless any of that's prescribed. Then you have 24 hours to provide a prescription to us. As to drug testing, I'm not worried about you taking illegal substances, truly. I am worried about you taking your prescription medications. So the testing will not be for illegal substances per se. They will be to check that you are taking the levels of psychotropic medication that you are supposed to take. The history here is clear. It is not lost on me, and I'm not a physician. But I've been an attorney 40 plus years and a judge 22 years, and it's not lost on me that there's a cycle for people who have mental illness, okay? And as soon as you start to feel normalized, you think you don't need medicine anymore and you go downhill. So I want to make sure you're taking your medication. And there's no stigma with having to take the medication or even with the label of mental illness, unless you don't take your medicine. It's just like cancer. You got cancer, you go to chemo. You treat yourself to get better. So make sure you take your medicine even when you think you're doing well and don't need it. You need it, sir. So the drug testing will be for that. You will make a truthful report to probation monthly. They can see you more often, or as things progress, perhaps less often. I leave that up to their capable hands. You will take all psychotropic medication and other medication as prescribed by your physician. You are not allowed to change it without permission of your treating physician. You will not treat with that so-called doctor up north who said you didn't need the psychotropic medication. I think you've got some other medication or other doctors, or you're going to find some in Charleroi. What's going on there?
Yeah.
You got the ones
Yes,
that are lined up? That's what I thought. Okay. You'll sign all necessary releases so that probation can verify that you're doing what you need to do following doctor's recommendations. We do not ask, we're not going to violate HIPAA. I don't care what you say or what you do with your doctor. All I want to know is, are you following the recommendations of your treating physicians and your psychiatrists or psychologists? You'll notify probation within 24 hours of any address, employment status, or cell phone change. Once you're employed, you will not give your employer any cause to terminate you. If at any time you are not employed, you'll be part of a work seeker program. You'll obey all court orders, recommendations from probation, and all of your treatment providers. Those become orders of this court. You will not engage in any assaultive, abusive, threatening, or intimidating behavior. You will not have any verbal, written, electronic, or physical contact with anyone housed in the Michigan Department of Corrections who's on probation or parole without permission of probation. You don't have to ask everybody if they're on probation or parole, but when you find out that maybe you're working with someone who's on probation or parole, just let probation know. As long as everybody's in good standing, I would allow the contact. You'll contact probation within 24 hours of your release, and you'll allow probation into your residence at any time for probation supervision without a warrant, and submit to a search of your person and property, including but not limited to your vehicle, cell phone, residence, and computer if there's reasonable cause to believe you have items that might violate the conditions of your probation. You must report any arrest, police contact, personal protection order placed on you, loss of employment or change of residence to probation within 24 hours. Weekends and holidays are accepted. So if something happens on a Friday, you tell us on Monday. If Monday's a holiday, you tell us on Tuesday. You will serve 681 days with credit for 681 days already served. To pay a crime victim's assessment in the amount of $130 and $136 state costs. So that is $266, and you will arrange a payment plan. I don't care if you pay $1 a month, but you'll get it all paid one way or the other. I am waiving fines and costs. I find that you're indigent for that. There is an indigency grant. I know you've been locked up for a long time. It's not up to your family to pay for the teller. There's an indigency grant for the teller. So hopefully you will be able to get that. You'll not use any object as a weapon. You'll not own, use, possess, or have any type of weapon or imitation of a weapon. No firearms, no ammunition. You'll not use any object as a weapon. That includes your mouth. You will not threaten anybody, verbally or otherwise. You will participate in cognitive behavioral. I know you've done that, some of that already. You'll remain in individual and group therapy. You will have the issue of restitution will remain open. I'm going to have that open for 6 months in regard to Next Star, NEXSTAR. I don't know whether I'll grant that or not, but they certainly have an entitlement to ask, and then we'll have a restitution hearing, let your attorney know. Now, in regard to the move to Charlevoix, I will allow that, okay? But you first have to meet with probation here. They're going to go through your probation orders, and then they have to contact Charlevoix. Charlevoix then has to accept you, and then you will be in Charlevoix probation. So if for some reason, I've never seen them not accept anyone, but there's always a first time. If for some reason they don't accept you, but you want to live in Charlevoix, I actually think that's a good idea. I would allow check-in through Zoom or telephone, and then he'd have to personally report when and if to hold. So there's a number of ways we can handle this. Now, we will also participate in any other psychological thing that your doctors recommend. And again, we just need releases. I don't even need to see the report, just that whatever the recommendation is, you're following it. Is there anything I have missed on behalf of the victims or probation, aside from his rights?
Your Honor, as it pertains to the 5 named victims, I would ask that the GPS tether include exclusion zones and victim notification if the victim so chooses.
Agreed, so ordered.
And then as it pertains to the probation, Your Honor, MCL 771.2, subsection 10 tells us that a defendant who is convicted of 1 or more of the following crimes is not eligible for reduced probation under the section.
For what probation?
For reduced probation, in other words, the half.
Okay.
Getting off probation in half the time. And subsection D as in dog is 411I. So aggravated stalking is not eligible for early
Okay, good to know. Anything else?
I think that covers it, Your Honor. Thank you.
All right,
Your
and
Honor, I have one question on the probation.
Yep.
He was on successful probation for 8 months, maybe a little. I presume that credits towards his 10 years.
nope.
That also wasn't probation, Your Honor. That was bond.
Okay. And ask.
I understand, yeah, big difference, as you know, counsel. Nice try, creative lawyering is always acceptable in this courtroom, but difference between bond conditions and probation. So, anything else?
What,
You
no,
have 42 days to appeal and to request appellate counsel. So if you're unhappy with this, you certainly can appeal. Please give him his appellate rights.
I will hand them to him and they're filled out. If you want to appeal, you have 42
days.
days to do so. And then if you need an appointed attorney, because you fill that out.
am I being released today yet?
Well, I don't know. It's up to the jail and yeah, Mr. Counsel.
It'll be soon. Your Honor, the other thing I just remembered, I think it might be best to sentence him to 365 J's jail with the 681 because 681 appears to be a.
I wondered about that, yeah. So it's really the 365 that says the jail time's done with credit for 681. So if they ended up going to prison, they would give you credit for all that. It may very well be 682. I don't know if you're released today. They've got to deal with the tether issue. So I don't know if you're released today or tomorrow.
I just want to make sure I'm clear on this. So in terms of reporting to probation, obviously,
24 hours,
I'm
yeah.
going to take him down and do it today.
That'd be
And
fine.
that's the reporting, and then he can do the other by Zoom from Charlotte, I presume is released from the jail.
Whatever
Thank
they arrange.
Didn't want it,
If
no
there's a
mistake.
problem, let us know. Anything else? Sir, you understand what no contact means?
Yes, ma'am.
Great. Any questions about anything I've ordered?
No.
Great. Thank you.
Thank you.
Thank you, Your Honor.
That's all for the record.
Good morning once again, everybody. It is TCF Live on a modified Super Friday today. My name is Dan. Good to have you here. Judging from the stats I see, there are new faces out there. If you're new, do us a favor, say hello in the chat. We'd love to hear from you. Again, no real courts of significance running today. There's a landlord-tenant in going with Judge Middleton, and there have been some very brief magistrate courts, but nothing of substance. So I'm going to show you a motion to suppress hearing in Judge Mogan's court from yesterday. But before we go there, let's go to Judge DeSanto, her docket yesterday, and we'll spend a hearing or two there just to kind of break things up before we go into another long hearing, because that suppression hearing is about 90 minutes as well. So let's go spend a minute or two with Judge DeSanto.
For the record, please.
Madison Mullins.
Okay, and so today's the date scheduled for the formal hearing on your matter. You did have an appointed attorney representing you last week on your felony matter, but the attorney is not appointed on a civil infraction. So you had an opportunity to speak with the prosecuting attorney today, correct?
Yes.
And you are going to be pleading responsible, is that correct?
Yes.
All right, please raise your right hand. You solemnly swear or affirm the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes.
All right. And as to the allegation on March 27th of 2026 that you improperly displayed a license plate, how do you plead? Responsible or not responsible? You understand you do have the right to have a contested hearing in this matter. By entering into a plea, you will not have that contested hearing. Do you understand that?
Yeah.
And you also understand the possible penalty as a result of your plea?
Yeah.
Whether in this court, any other court, or administrative agency. All right. And this may or may not be an abstractable offense on your on your driving record. Do you understand that?
Yeah.
Okay. Knowing all that, do you want to continue with your plea?
Yeah.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea today?
No.
Any immigration issues?
No.
All right. And the court does find the plea as knowing and voluntary. The court will accept your plea as charged, and the recommendation is to waive fines and costs. So I guess I'll adopt the recommendation, and you're all set.
Thank you.
Have a good day. And you're on the record in the matter of the state of Michigan versus Dylan Grove, 26729.
Good morning, Your Honor. Sarah Kraus. I'm appearing on behalf of Dylan Grove. Mr. Grove, can you state your name, please?
Dylan Grove.
Good morning. I didn't even see you sitting there, counsel. Good morning. All right. And you're standing in for the attorney of record?
Yes, I am. The attorney of record is David Cripps.
Okay. And is there an appearance file? There must have been. I just don't seem to have it. No, it must have been because his name's showing on the docket, but I don't seem to have it. But okay. And so today's the date scheduled in this matter. First, I'm sorry. Is that with you're standing in place of Mr. Cripps with permission from your client?
Yes,
Yes,
Mr.
Your
Grove.
Honor.
Okay, very good. All right. So counsel, today is the date scheduled for the adjourned pretrial in this matter.
That's correct. We have had a chance to review the discovery. I did have a chance to speak with Mohammed. We do have a resolution in this case. Mr. Grove would be pleading no contest to OWI first.
And what's the basis of the no contest plea?
Lack of memory, Judge.
Okay, I don't have a sheet for filled out from. I know that we have this sheet right here, but we just need the one that we have here at the court. And because that doesn't indicate, I don't see an indication as to whether your client, the agreements for your client to plead guilty or no contest. So counsel, I'm going to ask you to do, because it reads on here, you will plead to the following charge on the settlement offer, doesn't indicate guilty or no contest. So I'm going to ask you to please chat with Mr. Mohammed, and then there's the plea form that we use for all of our cases that will indicate all of that, and then we can move forward.
Okay.
Okay, thank you. All right, this is the matter of the state of Michigan versus Cherie Parks, 241534.
Ms. Sparks. Good morning, ma'am. Please, this most honorable court, Attorney Mitchell appearing on behalf of Ms. Parks, who's approaching now. Please state your name for the record. Cherie.
All right, and good morning to you both. Today is the date scheduled for a show cause hearing in this matter for your client's lack of payment of $950 in fines and costs after she was discharged from probation, it appears.
Yes, she has been making monthly payments on her. She thinks that it's been such a low amount, it wasn't enough to cover the full amount. She's been making $25 payments. And she states that that's as much as she can afford to pay. She's also recently been sick on her. She's been wearing her mask. She said she came down with an extreme illness. It was never diagnosed. She thought it was COVID. It wasn't, so she's still wearing her mask. If you can look, her eyes are super, she doesn't know, like she's having some physical health problems that I just would like for your honor to take notice of.
Okay. Okay. And so, ma'am, you've been making $25 per month payments. When did you miss a payment or two?
Not that I'm aware of, no.
Okay, I'm just wondering,
Yeah, I didn't see any allegations to say she missed the money. I think they just counted, so I subtracted the number, you know, and she told me it was $25. I think that wasn't enough to.
okay. So what's the current balance?
$950.
Lisa, yeah. Well, I think the balance is $950 as of, May 18th. Did you make another payment?
Yes.
Okay, so $925, presumably.
I see 900, Judge.
900. Okay, 2 more payments. Okay. Okay, well, and you don't have any ability to pay more than $25 per month?
I'm not paying if that's a requirement,
Well,
because she just informed me that it was 50. But that's not what you and I discussed when I was here the last time. I assumed that was all they asked.
did I set the payment plan at $25 a month for you?
That lawyer, the guy that stood in, I don't know.
Really? Let me see. No, the show's $50 per month, ma'am, beginning January 9th of 2025.
Your Honor, I explained that to my client and showed that to her as well, but she thought it was 25. She was
Okay.
making those payments, but the bottom line was it wasn't enough to cover the amount due, Your Honor.
Okay,
I'm not sure if the 50 would have covered enough to close it out within that time frame. I told her that we was probably hoping she could make bigger lump sum payments, you know, to come up with a bigger amount that you can close it out. And so she was like, whatever I need to do, I'm willing to do that. I didn't know if you could close out and send a cost to the state of Michigan. I didn't know what options we had today. So we're at Your Honor's mercy on this.
okay. So, let's put it back to $50 a month, ma'am, all right? Because a couple of things. Number one, that will allow you to pay that off a little sooner. And then, that will be able to, get this closed out then, okay? And what date of the month are you making those payments, ma'am?
It was the Tuesday I visited, Marcy Shine. I didn't have a specific date.
Okay, so let's pick a specific date so that it's the same date every month. Which date works best for you?
The date, so that if you get a check, you get paid once a week or every 2 weeks. So we need to look at the calendar. Today is the 18th of Thursday, June. So if you got paid a week ago, you really get paid on the 26th. Okay, so do you wanna? Is that June? Yeah, the first 26th of the month.
So it's even right behind you if that's close, if that's easy for you to look at, or if you have to walk over there.
24.
24th?
Yes,
Sam?
yes,
Okay,
of July.
No, we're talking about the.
Oh, so I was right, the 26.
Okay, so you wanna make payments the 26th, 26th of the month?
okay, so do you want to begin that June 26th?
I'm sorry.
Would you like to begin that June 26th? Okay, all right. All right, so we'll do that. So we'll just adjourn the show cause to a date if you miss a payment. Otherwise, you won't have to come back. Okay?
All right, thank you so much.
Thank you. Have a good day. You can stop at the window as well, ma'am, if you'd like to make online payments. You can get information about that.
Okay.
Okay.
Alrighty, friends, need to catch up on a couple of things here. Apparently on a holiday, the notifications also take a day off, because I haven't got notifications for stuff, so I had to go looking. Ashley donated $10 over at thecourtroomfiles.com. Says, thank you, Dan, for streaming on a non-court streaming day. You're welcome, Ashley. It's good to do it. And Gigi gave us $10 over there as well for your support of me and the chat of TCF. Gigi, thank you, and we've missed you. It's good to have you back. And also, Barbara gave us $10 over on Cash App. Thanks for putting this together for us, Dan. You are welcome, Barbara. I think I'm caught up now, and I've got all of those different portals open, so if they're not sending me notifications, I can actually see things now. Okie dokie, let's go to Wisconsin. This is yesterday. This was Judge Mogan, and again, this is a suppression hearing. I have not watched it in full, no idea how it's going to turn out or anything, so let's dig into it together. And again, this is about a 90-minute or so hearing, just like the Akalina hearing was.
We will go on the record in the matter 25 CF 86, State of Wisconsin versus Ryan Richardson. The state appears through District Attorney Kevin Schmidt in person. We do have Micah Paul, defense counsel, in person with his client, Mr. Richardson. We're set today in this matter for suppression hearing. Are we ready to begin?
Yes, Your Honor.
All right, the state, please call your first witness.
My first witness, I call Amy Tex. I will.
Amy Tex, please come forward, raise your right hand, be sworn in. You will have a seat at the witness stand.
Do you swear that the testimony you're about to provide today in this matter is the truth, the whole truth, and nothing but the truth?
I do. Okay, you may begin.
And I'll be using audio video pretty soon into this. I'm just giving the court a heads up. Could you state your name for the record?
Amy Tex, last name spelled Thiex.
And what do you do for a living?
I work at the Burnett County Sheriff's Office, currently the communications supervisor.
That supervises dispatch?
Correct.
How long have you been so employed at the Burnett County Sheriff's Office?
25 years.
Are you a sworn law enforcement officer?
Yes, I am.
Do you sometimes do the dispatching?
Yes, I do.
Were you doing dispatching on June 21st, 2025?
Yes, I was.
On that date, did you field some calls about an erratic driver and dispatch some deputies?
Yes, I did.
And you also prepared the radio traffic on a file for the district attorney's office?
Yes, I did.
How did you go about preparing that file?
I retrieved the audio from our software. I selected all of the transmissions that pertain to this particular case, recorded them into one file, and then provided it electronically to the district attorney's office.
As to that day?
Yes, just to that day.
Do you recognize the flash drive in my left hand?
Yes, I do.
How do you recognize it?
I recognize it as a flash drive provided with the electronic file of the radio traffic, the phone call and radio traffic from that particular day in dispatch.
Okay. I'm going to play you a portion of that. Oh.
Is it audio or video?
This one will be audio. And you reviewed this file before you sent it?
Yes, I did.
And it's a true and accurate recording of the dispatch recordings?
Correct.
Okay.
Burnett County 911.
And to clarify then, these are the dispatch recordings from that date, June 21st, 2025, about that erratic call and the call to service.
That's correct.
Okay.
Yeah, there's a guy road raging south of Grantsburg on 87. His license plate's RKL666.
Where are you? Are you by them now?
I'm driving southbound on 87.
Where on 87?
What's that?
Where? Do you have a crossroad?
Just passing Fish Lake Road.
When you say he's road raging, what do you mean exactly? What is he doing?
So I came up to the intersection in town and it was a red light for me and he was like sitting in the middle of the intersection and then he like took a right, pulled into the parking lot. I don't even know what his deal is. I didn't see what happened or I didn't see anything. And then he like floors it out of the parking lot there, runs up behind me, passes me in town in the 30-mile-an-hour zone there. And then just about hits the guy in front of me, locks his brakes up. And then he like up ahead of us and stopped on the side of the road. And then he cut me off and got right up on the guy in front of me again. And then now he's way off ahead of me now. I don't know what his deal is.
Okay, can I get your name?
Jason Short.
715-553-1496.
Yep.
Do you still see him?
No, I don't.
No? Okay.
There's a curve up ahead of me. I'm almost to the
Is he in front of you?
wildlife there.
What's that? He passed you and then he went up to the next vehicle, correct?
Yeah, he passed me, just about hit the car in front of me, and then he like passed him, went way off ahead, and then stopped on the side of the road and waited for us to come up, and then he took off again. He's gone now. I can see up a mile ahead, and he's nowhere to be seen now. So
Okay. Alrighty, we'll pass it along to Polk County and give it to our people as well.
Okay.
Anybody in position, but we'll give it to
Yeah, it was like a Tahoe or something, Minnesota plate, RKL666. So. All right,
Okay.
Thank you.
Yep, thank you. Bye.
And that was you talking to that caller?
No, that was the second dispatcher on duty. There's two of us on shift.
But you were present there when that happened?
Yes, I was.
Where's your emergency?
We are driving on 87 headed through Branstead, and there's a guy that was at the stoplight in Grantsburg passed out. He is now on the road behind us in a black pickup truck, driving incredibly erratically.
Okay.
He's in an SUV, black, kind of Chevy Blazer looking, older. He's everywhere on the road.
Okay, 1 second.
There's a lot of traffic coming. He is gonna hit somebody.
Okay,
Oh,
1
God.
second. So you're south of Branstead now?
Yeah, we're south of Branstead. We're passing the church, Bethany Church. And he is speeding up way fast, coming up on us really, really fast.
Okay, are you able to maybe
Once he
pull
gets
over?
past us, yeah, we're pulling over.
He did pass you?
He has passed us now. He is going like RKL666. He's burning oil. as he's going.
666. You said he's burning what?
Burning oil as he's going.
Burning oil.
You can see the smoke.
Okay. Okay. What is your name?
My name is Tammy. Last name Thoreen. He's doing about 80 now.
Okay.
We can't keep up. We're not keeping up with him.
Yeah, no, that's fine. I'm showing your number 4310374.
Yes, you are correct.
Okay. All right. I will give this out to our officers, and I'm going to also notify Polk County. Okay.
Yeah.
Where are you headed to?
We are headed to, we're going to Lindstrom.
Okay. All right. Well, you just continue on your way. You know, obviously try and avoid him if you come up by him
He's
again.
turning on. He's got his blinker on to go on 48 now.
Okay, turning on 48. Sounds.
Is he actually? Yes, he's turning. Yes.
Okay, sounds good. We'll give this to our officers. All right.
Okay. Thank you.
Yep. Thanks for calling. Bye bye.
Yep. Bye bye.
Burnett County 911. Where's your emergency?
Hi, I'm heading towards St. Croix Falls, on 87, and I just had somebody try to run me off the road.
Okay, was it a black vehicle?
It was like a, bluish black, like Suburban vehicle.
Okay.
It had Minnesota plate. I didn't quite catch the plate number.
All right, we've gotten a couple calls on this car. My previous caller said that it had turned off on State Road 48. Were you north of State Road 48 when this occurred?
Yeah, I was just coming out of Grantsburg.
Okay. What can I get your name and number, and I will add this to our information. What is your name?
Brittany Fleischauer.
Brittany.
Ney.
Ney. Okay. Fleischauer. All right, Brittany, what's your phone number?
715.
Yep.
431.
Okay.
1210.
Okay, sounds good. I will add this to the call. Thank you very much.
Yep. I got a little bit of a description of him. He's got
go ahead.
Reddish blonde hair. He's got a scruffy kind of beard. Or it's very short, scruffy beard. Same color as his hair.
Okay, sounds good. We'll add that to the call. Thank you very much.
All right, thanks.
Okay, yep, you're welcome.
Right.
Bye-bye.
Bye.
Which way was the erratic driver head?
The last information we had was the vehicle had turned onto State Road 48 from 87. I did receive a call from a third party who was ran off the road by this vehicle. They were traveling southbound 87 between the stoplights and 48. She was ran off the road prior to him turning.
At what point were the deputies that were dispatched?
They were dispatched right after the first call.
And why isn't there any radio traffic of them being dispatched?
Because they were present in the dispatch center at the time that the call came in.
So they were just told to go out and investigate this by you?
Yes.
Okay. So when there was a call in there asking about the dispatch, or question there about the driver, they're already out in the field.
Yes.
So I've just played about 7 minutes and 30 seconds of audio. Did all this actually transpire in 7 minutes and 30 seconds?
No, as I said before, I took each of the calls and the radio transmissions and I recorded them into one file. I compressed them into one recording. That is not an accurate time frame of the actual calls. All three calls was not all in that one file, or
so this is the order of the call.
It's the order of the call, correct?
But the dead space was cut out.
There was dead space, and I removed that from the call, so it's just the recordings pertaining to the call.
Okay.
Vehicle is described as a blue or black colored suburban type vehicle. Driver described as a male, reddish blonde hair with a short scruffy beard.
So that's the description given by the person who called out to the deputies over the radio.
Yes.
Okay.
to 29. I'll take W south.
Burnett 519529. Just be advised I ran the 27 on the RO. He is revoked. Lengthy driving record, including high rate of speed and fleeing peace officer.
519 Burnett, I copy.
529 simple. 936.
519 Burnett, do you want to check land record and see if he has any property here in the county?
10-4. No history in land records. Polk or Burnett.
Burnett.
519.
Burnett, I'll be jumping into Polk just for a couple minutes here to catch back into our county off Whispering Pines.
10-4.
519 Burnett, I'm back in our county.
10-4. 529.
I'll be out with a male individual on 87 by the fairgrounds. That bike's been pretty tuned up.
10-4. 529 Burnett, can you run Ryan Richardson?
Yeah.
Male or female?
Male.
10-4. 529, I don't have a male Ryan Richardson in-house. Ryan, R-Y-A-N, Richardson. R-I-C-H-A-R-D. Simple. At 529. Brian is canceled, ID card only, inimical to public safety. He's negative 29.
When it was related that he was inimical to public safety, what does that mean?
That there is an extensive driving history, typically alcohol-related offenses.
What does it mean about his license?
Canceled?
That he doesn't have one?
That he doesn't have one, correct.
Thank you.
529.
That would be clear from speaking with him. It sounds like this vehicle we're looking for is probably his. He doesn't know where it's at. Just that he drives a black Tahoe.
And 4956.
49 to 29. Do you think he was on driving and just parked it somewhere?
I'm thinking so. He said he has no idea where he's put it.
Got it.
I think I saw it parked back in somebody's drive. Turn around and go back.
Copy.
529 Renee. 529. That'll be all with it. It's in a entrance cornfield. Minnesota 28 RLK 666. 10-4, 958. There's no address here, but it's right across from 23327 State Road 4887. 10-4. Can you copy the last four of this then? Go ahead. Last four are 0767. 0767. 10-4. That does match the VIN on the license plate that was given.
That statement there about the VIN matching the license plate given, is that relating to the one given by the callers?
Yes, because that was the same plate that Deputy Krupa ran.
The RKL 666?
666, correct. That is the same plate that was given.
The description of the driver given by the reporting parties was reddish blonde hair with a short, scruffy beard matching the hair color. Yeah, 10-4, that's the same on him. 10-4.
9-29, any idea where he went?
He was gonna go downtown to the bar. He had a white t-shirt on, blue jeans. I'll stop over here at the gas station, see if he's in here.
Okay, so I want to clarify a couple things then off of that. Who were the deputies that were dispatched?
Deputy Karen Krupa and Deputy Brady Mangan.
So the voices we heard on here, that was their voices,
Yes, it was.
as well as dispatch conversing with them.
Yes.
Information that's sent out through the radio on dispatch, does everybody hear that?
Yes.
And by everybody, I mean like all of law enforcement on that frequency?
Yes, that has the radio on and on duty, correct.
Okay. I have no other questions for this witness.
Mr. Paul?
When 911 calls are received, who on the department's end can hear a given call, specifically what the caller is saying as that call is ongoing?
The dispatcher?
So the person taking the phone call.
Correct.
Can the other dispatcher hear the other dispatcher's calls as they're ongoing?
Yes, if it's, if it's necessary, we can monitor, correct.
But is that standard? Is it that like it's a speaker and it comes out into the whole room?
No, not like
Yes.
that.
Do you wear headsets?
Some do, some do not.
Okay. Can the deputies hear these calls while they're ongoing?
No,
Okay, so Deputy Krupa wouldn't have heard this call on the day in question.
not coming through the phone, no.
And it doesn't come through the radio traffic.
No, it's taken by the dispatcher.
Right, and Deputy Mangan wouldn't have heard this call either.
Correct.
The only information that they would have known from these calls is the information that was conveyed over the radio traffic by the dispatcher. Is that right?
In this case, it was given to them in person. They were in the dispatch center.
Okay, was there any information that was conveyed to either Deputy Krupa or Deputy Mangan that differs than what we heard in the radio traffic?
Not to my knowledge.
Okay. Last question, completely unrelated to the first things we were talking about. Who is the vehicle that Deputy Krupa discovered registered to?
I believe she said it was Ryan Richardson.
She said it was Ryan Richardson?
Yeah.
So the vehicle with the Minnesota plates and the VIN number was registered to Ryan Richardson?
I believe so.
Okay. I don't have any further questions.
Redirect.
Just the reason you believe so is because of what you heard on the video right now.
Correct.
You don't have any personal knowledge recalling running it yourself.
I don't recall like all that I ran that day.
Okay, thank you.
Yeah.
Can I recross just on that?
Yes.
So we heard in the video someone running the registration. That wasn't you?
That was me. But
Oh, that was you.
That was me
Okay.
in the audio, correct.
And
I just don't,
that's okay.
Okay,
I'm
just-
asking.
it's just my memory.
So do you know why when you first heard Ryan Richardson's name come over the radio, why you had to confirm the spelling?
We always confirm this. I mean, it's common practice to confirm the spelling to make sure that we're making an accurate query on the right person.
And it sounded like, and I may not be remembering this correctly, but it sounded like the first time that it came through that someone was told that we don't have a Ryan Richardson in-house. What was meant by that?
We're actually going way beyond direct.
Okay. I don't have
I'll
any.
allow that because, I mean, I know what it means. If you don't know what it means or you want it on the record, you may answer.
Can you answer? Do you want me to?
Can you
ask
just tell me one more time, please? Or question me one more time?
What does it mean when you're saying somebody is in-house?
I'm checking our database to see if I have a name matching the name given to me. If I don't have it, then I'm going to ask for a further spelling, name, date of birth, all the things required to make a full query.
And you wouldn't have it even though you just, in theory, ran the VIN number and the license plate number.
I don't have it in my, if we'd not have had contact with him before in the past, I would not have it.
Okay, I understand. I don't have anything further.
Mr. Schmidt?
No.
All right, you may step down. Thank you. Okay. Next witness.
Next, I call Karen Krupa.
Deputy Krupa, please come forward, raise your right hand. You'll be sworn in and have a seat at the witness stand.
Do you swear that the testimony you're about to provide today in this matter is the truth, the whole truth, and nothing but the truth?
Yes. Could you state your name for the record?
Karen Krupa, first name is spelled Caryn, last name Krupa.
What do you do for a living?
I'm currently a deputy with the Burnett County Sheriff's Department
How long have you been so employed?
since August of 2019.
And